A party's offer of settlement can signal that a claim has merit. Although settlement negotiations might contain relevant proof of a claim, the rules of evidence keep them out of court. Barring evidence of negotiations encourages parties to settle. Davidson v. Prince considers the scope of this evidentiary ban. The court queries whether a letter demanding full payment should be excluded as a settlement negotiation. Erwin Prince was driving a truck full of cattle for his employer, Folkens Brothers Trucking. Prince overturned the truck, freeing the animals. The cattle ran onto the roadway and into the surrounding area. Grant Davidson was working nearby. A steer charged at Davidson and gored him. Davidson sued Prince and the trucking company for negligence. In a deposition, Davidson testified that the steer had charged at him from a distance of 40 feet. Davidson claimed that the defendants were fully responsible for his injuries. Prince and the trucking company claimed Davidson was at fault. They argued that Davidson had cornered the steer, causing it to charge. To support their theory, they offered a letter into evidence. The letter was written by Davidson to the defendants. In the letter, Davidson began by recounting the events leading up to his injuries and admitted being much closer than 40 feet from the animal. Davidson wrote that he, quote, stopped and got out some 10 feet from the animal, unquote. After reciting facts, the letter made a demand. Davidson wrote that he didn't intend to let the defendants off the hook simply because they'd sent a letter disclaiming liability. Davidson concluded, quote, "You may speak with us directly, or we can send it to lawyers and court. You decide," unquote. The court admitted the letter over Davidson's objection that the letter was an inadmissible settlement negotiation. The jury found that Prince and the trucking company were negligent and that Davidson was also negligent. The jury reduced Davidson's damages by 40%, the proportion of fault assigned to him. Davidson appealed to the Utah Court of Appeals.